Welcome back, students. The week before you left for the break, we were looking at the introduction to the topic of tort, and I took you through some of the basics of tort. And as you all know, tort is defined as a civil wrong as opposed to a criminal wrong, because criminal wrongs are under the category of criminal law, which is an area of public law, and tort is a civil wrong, and it comes under the area of private law. Right now, so when you look at tort, in the last class, we saw that tort can consist of a spoken wrong, that's something that you speak. It can actually be a tort, all right, or it can be an act. That means an action that is considered as a tort. So it can either be a spoken wrong or an action, or sometimes it can even include a non-action. And as a result of your spoken wrong or action or non-action, the other person has suffered either injury or losses or damages to their property. Okay, so that is the overview of what a tort is and its definition. Now we looked at torts and we saw that basically if somebody commits a tort against you, you have got certain remedies available when you bring the action in court as a plaintiff. And normally your remedy involves either monetary damages, where you claim certain amount of monetary damages for injuries or losses that you have sustained because the other person has committed a tort against you. You can also, obtain an injunction, meaning to stop that person from continuing with that tort against you. And sometimes, if the tort is something that is really very serious, the court can even, impose punitive damages or nominal damages against, the person who is committing the tort. Now, so this is basically the remedies available for most torts that a plaintiff can actually apply for, right? Now, if you look at tort, it is a private wrong, right? Private, a wrong committed against you. And of course, it's non-contractual in nature, meaning it's got nothing to do with contract. Now, in contract, two parties come together, they agree on their duties and obligations. So the duties and obligations under a contract is imposed by the parties themselves, whereas in tort, it is actually imposed by society. All right. So generally, there is a code of conduct in most societies on what is considered as acceptable conduct or conducts that are not acceptable, right? And normally, society will impose duties on how you are supposed to, behave in certain situations. And if you go against this standard of conduct, then you have committed a civil wrong. If the person to whom you have committed the civil wrong suffers some form of harm. Okay, so tort is a non-contractual interaction in which one party wrongfully harms another party, and therefore the person who suffers the harm can actually bring a lawsuit against the person who has caused him harm. Okay, now, what are the liabilities? So normally when you bring a case in court, you have to actually prove three things to show that you are entitled to obtain relief against the other person. Relief in the form of either damages or injunction, right? Now, what must you prove as the plaintiff? Firstly, you must prove that the other person, who is the defendant, owes you, the plaintiff, a duty of care, right? So that means, the defendant in general has a duty of care towards you, right? Secondly, you must prove that this person who is the defendant, has actually committed a breach in that duty, meaning he did not, carry out his duty of care. In other words, he has breached his duty of care towards you, and therefore the plaintiff, is a victim of that breach. Then you have to show that as a direct result of that breach, or that breach has directly caused you harm in the form of damages to your property, losses to your property, or injury to yourself. All right, so these are the three things that the plaintiff who brings the case against defendant must prove in court in order to entitle himself to the remedies that he is asking the court. Okay, now we saw also that torts are classified into three general categories, one being intentional torts, the other being negligence, and third being strict liability torts. Now, of course, how you are supposed to prove these cases are different, all right? So, but generally you can see that for intentional torts, that means the defendant has intentionally committed that civil wrong against you, you are also entitled to not only monetary damages in the form of compensation, but you're also entitled to punitive damages, right? The other category of tort is what you call negligence, meaning the person did not cause harm on you intentionally, but he was careless, and he did not exercise the sufficient care when he did something or said something, and he was negligent, and therefore you had suffered harm, right? Again, okay, you can actually ask for remedies for the amount of harm that has resulted to you, right? And then finally, you have got strict liability torts. These are certain areas where the law imposes strict liability in certain situations, right? An example is things like, product liability, strict liability imposed on manufacturers for the safety of their products. They have to have a certain safety standard that they must comply with. Another example is occupational safety and health. Employers are required to ensure that their workplace is sufficiently safe, and also sufficiently healthy for their employees. So all of these, the law will impose strict liability, meaning if any harm occurs to the consumers in terms of product liability, or in terms of the employees in their workplaces, when they bring the case to court, they don't have to prove, that there was intention, or they did not have to prove there was a breach of the duty of care. All they have to prove is they have suffered harm. Automatically, the court will impose the necessary remedies because of that. So it's much more, the standard is much more higher, the standard of care for strict liability torts, because the plaintiff don't have to prove that you have either intention or that you were negligent, right? They automatically just have to prove the part that they have suffered harm. Okay, now we already did looked at the types of damages, and we looked at intentional torts and the 5 types of intentional torts. We looked at those, right? And basically, you have to prove that the defendant knew what he was doing and that he knew the consequences of his actions, right? Now we also looked at the concept of privacy, right? And my question to you has been whether the Malaysian Constitution has got any provisions that protects privacy of the individual. In the United States, they have the Fourth Amendment that protects the privacy of the individual. And I played the video and what privacy is and why it is important in an age where a lot of information about you, which is private, is out there, and it can be used for the wrong purposes by corporations or by governments. Now, for your information, there is going to be a question in your finals on privacy, and you can actually specifically look at certain challenges in relation to privacy that has arisen in the context of COVID-19 and during the period in which governments have imposed certain measures that may actually encroach upon your privacy. All right. So these are issues that you need to actually discuss in one of your exam questions. Right now, I will play you this particular video that deals directly with not just privacy in general, but privacy in relation to online activities and social media.
So, you were born. Then you start living your life. Now you're entitled to your own social media profile. You're in. Welcome to your social media reality. Congratulations, you're 18 now. Do you want to know the other side of the story? Did you see the picture that was taken and uploaded by your parents? This information was collected, analyzed, and may be sold by the social media to its affiliates and partners. Even before you are conscious of it, you start existing on the internet, and data starts being compiled about you to be used sometime later. Let's have a further look. The internet knows where you studied, even before you had the chance to enter that information in the online space. This may not bother you. Who cares where you studied? But what happens when you started your own social media activities? Social media platforms, websites, and mobile applications collect, process, and profile your data into statistics that are ready to be sold. By agreeing to the terms and conditions of a social media network, websites, and mobile applications, you grant permissions to their owners to collect, process, and sell personal details such as information you provide, uploaded data containing information regarding your geolocation, which can help people track you down, information that other people provide, information about your devices from which you have logged on to social media, your location, operating system, and device settings, information about you visiting and using other websites which have integrated social media services. Even when you are not logged into your social media profile, these actors may provide information to social media. Information provided by social media's affiliates and partners. Information that the mobile application gathers from your phone. This data about you and millions of other users is utilized by companies. Actually, your likes, shares, and posts reveal a lot about your personality. Companies modify their goods and services, considering your preferences revealed to them through an analysis of your online behavior. They use models for profiling so as to extract information about your habits, habits that even you did not notice. They get insights on your preferences, sexual orientation, financial situation, social circle, political affiliation, and religious beliefs. They even try to judge what your level of intelligence is. Your next employer may have access to such information and may already know more about you than you know about yourself. Under certain circumstances, this data may also be used by public authorities for deciding whether you are a threat to national security. You may or may not be okay with this, but the important part is being aware of the other side of the story. Privacy policies usually contain a lot of text, but do always read your privacy policy and adjust your privacy settings. You can reap the benefits of the digital world, but you should do it in a smart way and protect yourself from risks. If you want to know as much as I do and more about online privacy and data protection, check out http://engaged.mappingtheinternet.eu/en.
Okay, so you have seen the implications of social media on privacy. Now I want to look at another aspect called data protection and what is data protection. And you can look at that video as well.
So, data. Data is all about you. You're the subject, the product, and the prize. And you're worth a small fortune to people who want to market things at you, people who want to predict your behavior, people who want to know everything about you. Meet data controllers. Data controllers are the architects and administrators of the devices, operating systems, and apps you use. Essentially, they follow you around, both online and offline, and include the companies and government departments you knowingly interact with, and also the ones you know nothing about. Sometimes they tease data out of you with a checkbox or a privacy setting. Sometimes they obtain it via things you post or publish or generate. But they also do it secretly, involving emitted information about you that you know nothing about. All this is collated and analysed to produce vast dossiers to be sold and shared at their whim, because in their eyes, they own you. This is where data protection law comes in. Data protection laws are designed to defend your personal information and your rights to know what happens to it. It's about safeguarding data from all those who want it and preventing it from being abused, but it's more powerful and complicated than you might think. Legal protections on data differ enormously around the world. More than 100 countries have implemented some level of data protection law, but these don't always cover every industry sector or government function. And because information travels around the world through borderless networks, even if you live somewhere where your data is protected, it will likely end up in countries that have different laws or none at all, which means you have no remedies if your rights are abused. This reaches new realms of problematicness when you consider that most of the world's information passes through tech HQs, and almost all of them are in the US. And under US law, non-Americans have no rights at all. In fact, US industry is spending crazy money all around the world lobbying for decreased protections of your data. In short, they know that the more rights you have, the more control you have, and the less they will earn off of your information. And this often works the same way for governments, because your protections limit their control over you and your data. Data protection law needs to prevent all this from happening. It needs to ensure that there are no secret databases and that the purpose for the data and its uses are specified at the time and not ever extended. Only data that is necessary should be collected, and it should be kept up to date, secure, and be deleted when no longer necessary. No information should ever be passed on without consent. Crucially, we should have access to our information and the right to challenge what's being held and to seek its deletion, rectification, or modification at any time we choose. All these rights are vital, but the final missing piece to this privacy protection puzzle has got to be ongoing accountability. We need an independent regulator to whom we can appeal, who can investigate, and who can enforce decisions against organisations. That's why Privacy International is working to protect your rights. Learn more about data protection on our website and get involved.
So, okay, you can see how important data protection is, and basically, what happens when you don't have control over your data. Now, if you look at Malaysia, we have got a Data Protection Act, and it does cover private sector, but it does not include information about you, which the government has, which means that the Data Protection Act does not cover how governments use your data. So that's already a major issue. And if a private sector, is involved in a project together with the government, then they are excluded from being covered by the Data Protection Act, because by virtue of the fact that they are in joint project with the government. All right, so you can
So
see
data. Data
why
is all
it
about
is very important for us to protect the data. And you can see that even though your data may be protected in your country, it may not be protected in another country, and therefore, once again, these people have access to your data. Now, in countries like Malaysia, where data protection is not really very strong or not complete in its scope, you'll find that in Europe it is much, stronger in its protection, and therefore you'll find that it does not encourage consumers to engage in activities with the private sectors in this part of the world. Right? Again, because they won't be able to protect the way the data of EU consumers are being utilized in countries that do not have strong protection. Next, I want you all to have a look at this video that looks at the connection between data protection and privacy, and hopefully, again, you get a rough idea on how important it is. Okay, for some reason I'm not able to play that particular video. I will see if I can do that at a later stage. Okay, so if you look at, when you talk about privacy, it comes under intentional torts, because people cannot violate your privacy without intending to, right? You cannot accidentally violate somebody's privacy. So it must be done intentionally, right? So basically, you can look at specific forms of invasion of privacy by private individuals. And these includes the commercial use of somebody's names or somebody's likeness without permission. Okay, now if you use somebody's name without their permission or somebody's image without their permission, that would be considered as misappropriation. Okay, misappropriation is a form of using someone's property without their permission, using someone's name without their permission, or someone's image without their permission, right? So another category of invasion of privacy has to do with intrusion into a person's solitude. That means normally there are certain areas that are considered to be private, and when you are in that area that is considered to be private, you are expected to have a certain form of, solitude, meaning you don't want to be disturbed when you are in that particular area or boundaries in that area, right? And when somebody else comes into that area and they search your premise or your belongings, or they tap into your telephone or handphone to hear what you're speaking, or they use certain, like a webcam, to actually see what you're doing, etc. That is considered to be an intrusion into a person's solitude. All right. So this is another form of invasion of privacy. Right now, so that's in private areas. People cannot do that. And if they do that, they are invading your privacy. Now, how about if you are at work, right? If it is an area where you are in your office, and there are certain cameras at workplaces, say, there's cameras placed in, say, for example, classrooms, or cameras placed in the office to monitor whether the employees are working or not, for example. Right? Is that an intrusion into a person's solitude? Okay. What if your employer places cameras in the bathrooms or in the dressing rooms, right? Or what if your employers require drug testing of employees, right? Or what if your employers require to take a polygraph testing to see whether you have, committed theft or other criminal acts, right? What if your employer requires you to do psychological testing and counseling? All right. Is that an invasion into your privacy? All right. What if your employer tries to track where you are surfing on the web using the company's computers? All right, or whom you are calling during office hours? All right, now is that considered to be an invasion of privacy? All right, so all of these things are actually part of intentional torts, or categories involving different degrees of invasion of privacy of individuals. Now, generally, monitoring done at the workplace is generally not considered to be intrusion into a person's solitude, because when you're at the workplace, the employer has a right over your time and what you do during that time, because he's paying your salary. But of course, things like placing cameras in the bathroom and dressing room will not be allowed. All right, so again, depending on how reasonable it is in that context. All right, now the next category of intentional tort is with regards to defamation. All right, does someone have the right to actually say whatever they want to about you, right? And say things that harm your reputation, right? On one hand, that person has the right to speak, right, which is covered by the First Amendment in the United States regarding freedom of speech. But that freedom of speech does not extend to making any statements that are untrue about another person and causes harm to that person's reputation. So, on one hand, you have the right to speak, or you have the freedom of speech, but you must make sure that you exert this right in a way that is, does not harm other people, especially if you are speaking untruths about another person to the extent that person's reputation is harmed. All right. So basically, when you talk about defamation, it consists of two categories. One is what you speak about another person in public. The other is what you write about another person, which is inaccessible to people who are in the public. All right. So one is about what you speak, the other is about what you write about a person. So whatever you speak, right, is called slander, right? So defamation consists of two categories. What you speak about another person in public, which is called slander, and what you write about another person, which is accessible to the public, which is called libel, right? So, these are two categories that come under defamation, right? Now, so when you look at the intentional tort of defamation, remedies will be provided if the plaintiff can prove that he has it has been seen, whatever he has been written about him has been seen or heard by third parties through a particular medium. The medium can be the internet, can be through letters, can be through radio, can be through television, so letters that are publicized. So that means the letter that you have written, suddenly it finds its way to the media and it's been published in the media. Right. So again, if you can prove that it has been seen or heard by the third parties through any of these mediums, then a remedy will be made available to you. And if anybody repeats that defamatory statement, let's just say you saw something in the radio or you heard something in the radio, and then you repeat that to another person, again, the person who repeats that defamatory statement can also be liable. So not only the first person who committed the defamatory act can be liable, but anybody who repeats what he or she saw or heard can also be liable. Okay, now what are the defenses? So say the plaintiff brings an action against the defendant. The defendant can defend himself by saying that whatever he had spoken or written is the truth. So truth is actually a defense in an action of defamation, right? Or you can say that it is actually absolute privilege for statements made by court and legislative personnel. So that means that particular statement is a statement that is protected by privilege because it's statements made by court or somebody in the parliament, for example, right? Or it is made in good faith, all right, a qualified privilege for statements made in good faith. Example, letters of recommendation. So if, say, for example, you ask for a letter of recommendation to be given when you are going to work for another employer, you will ask the current employer or your previous employer to issue you a letter of recommendation, and that person makes certain statements about you, right? These statements are actually protected because they are made in good faith. Another category of information that is covered or is protected is work performance evaluation. Now, normally when they evaluate your work performance and they come up with certain statements about how good your work performance is or how bad it is, again, that is a qualified privilege, right? And of course, if you look at public figures compared to us, right, those who are really famous, they are less shielded from statements that are defamatory in nature because of the fact that they are public figures. They expose themselves, in terms of what they do in public, like actors and actresses. So they do things in public in a way, so sometimes they attract certain criticisms or comments, and the level of protection against public figures are much less, compared to those who are in the private realm. All right, now, if you look at online defamation, you will find that it's a situation when good words go bad, right? And let's look at this video, right?
I'm Professor Mark Grabowski, and this lecture will cover online defamation, or making false statements about someone that seriously harms their reputation. Whether conveying simple, straightforward information or urging others to action, words matter deeply. And when used carelessly, words can cause harm, despite what the famous nursery rhyme says. It's important to understand online defamation because it can have serious consequences. You can be sued for millions of dollars if you do it. Online defamation is a topic that many students find complicated. While the law can get complicated for lawyers and judges trying to sort out the details after a defamation lawsuit is filed, the basic idea of defamation, which is enough for the average internet user to protect themselves from most lawsuits, is fairly straightforward. So what is defamation? Here is a definition. It is the broadcasting or publication of a false statement of fact that seriously harms someone's reputation. Online defamation
is also sometimes called slander or libel. It can occur online or offline. Here's an example of online defamation. If you post a tweet that says, Professor Johnson stole a school bus and used it for a family vacation this summer, you'd better be right. If you're wrong, you have probably seriously harmed, defamed Professor Johnson's reputation. Not too hard to understand, right? But we need to dig a bit deeper. Within this one-line definition are 5 things that the person suing, in this example, Professor Johnson, must show before he can successfully sue for defamation. And the Supreme Court added 1 more. Let's take a quick look at each of them. The first thing the person suing must show is that the defamatory statement has been published. That's usually pretty straightforward. It is important to understand, however, that a broadcasted or published statement can occur almost anywhere online. Newspaper websites and blogs are common sources of defamation, but defamatory statements can also appear in tweets, Yelp reviews, YouTube videos, podcasts, wikis, online discussion boards, and elsewhere. In addition to showing that the statement was broadcasted or published, a person suing must also show that he or she has been individually identified. In many cases, this is also pretty easy to determine. If a person is named, he or she will almost certainly meet the identification requirement. In other cases, it's not so clear. If you do not explicitly name the person, but provide enough specific details that there can be no confusion over whom you're referring to, the identification standard is met. So if you defame the government executive who makes his home at 1600 Pennsylvania Avenue, it is still reasonably identifiable as the president. If there is no identification, a person cannot successfully sue for defamation, even if he or she believes that they are the one targeted by a false accusation. Back to the third part of the definition of defamation, and it's very clear. Only false statements of fact can be defamatory. There are too many black and white rules in the law, but this is one of them. Truth is an absolute defense to a charge of defamation. Even though you might know that Professor Johnson took a bus without permission and used it for a family vacation, though, do you have sufficient, reliable evidence, for example, verifiable documents, police reports, photographs, trustworthy, unbiased witnesses, etc., to back your claim if Professor Johnson denies it? If you don't, you may not be able to rely on the truth to get you out of a defamation jam. On the other hand, if you know something is true and you can prove it, you can never be successfully sued for online defamation, no matter how much it might damage a person's reputation or how angry they might be. As the saying goes, a person is entitled to no greater reputation than they have earned. Next, the suing person must show that the defamatory statement is an assertion of fact, not an opinion. If a statement contains only opinion, it cannot be defamatory. Unfortunately, it is sometimes difficult to tell one from the other. In our example involving Professor Johnson, it is easy to tell that the statement is an assertion of fact. For one thing, facts are objective. They are either true or false. Either he unlawfully took the bus or he didn't. If instead you had simply said, Professor Johnson is horrible, the statement, which can't really be proven true or false, would be pure opinion and protected in a defamation lawsuit. Incidentally, this is one of the reasons why cyberbullying and internet trolling is so difficult to regulate. Most cyberbullying amounts to name-calling, statements like Johnny is fat, Pedro is ugly, or Rita is dumb. Although they are mean and they can seriously harm someone's feelings, they are not defamatory. Some statements contain both opinion and fact. For example, if you say, I think Professor Johnson is awful because he misused school property this summer, that's a mixed statement that might support a defamation claim. And be careful. Simply prefacing a statement with, in my opinion, will not protect you from a defamation claim if it contains untrue factual assertions. A close cousin of opinion is satire and humor. The publication of April Fool's emails, spoof articles on websites like The Onion, and other humorous or satirical online content occasionally prompts threats of defamation or other lawsuits by individuals who find themselves the target of ridicule. Generally, it's not a defense to defamation to claim that you were just trying to be funny or meant it only as a joke. Humor is not necessarily the same as opinion and does not enjoy blanket protection from lawsuits. However, if a statement cannot reasonably be interpreted by readers to be one of express or implied fact, it cannot be defamatory. In other words, as long as readers understand that a joke or a cartoon is not meant to be taken seriously, its subject cannot successfully sue for defamation. Subtle humor can be dangerous, though. For example, posting a photo to Instagram of a coach and an athlete and writing a joking comment that the two are having an affair might be funny to those who know it's a joke, but it might also be fairly believable to those who don't and possibly harm reputations. So to be safe, if you intend something as a joke, be sure that everyone will recognize it as such. Next up, in order to successfully sue for online defamation, the person suing must also show that the false statement about them caused serious harm to their reputation. Being mildly offended or embarrassed is not enough. Some statements about a person, if false, will almost always be sufficiently harmful to a person's reputation to support a defamation claim. For example, if you publish a statement that accuses a person of having committed a crime, such as stealing a school bus, your facts must be accurate because such accusations will almost always seriously harm a person's reputation. On the other hand, if you tweet that Professor Johnson gave you a dirty look in class today, he can't sue you for defamation even if you're lying. Once it's shown that a statement has been published, identifies a specific individual, is false, asserts a fact, and causes serious harm to a reputation, the person claiming defamation must still show one more thing when suing in an American court. The Supreme Court has said that in order to successfully sue for defamation, the First Amendment requires that the person suing must also show, at a minimum, that the defendant messed up, that he or she was somehow at fault. In other words, before you can be successfully sued, you must have done something a reasonable person would not have done or failed to do something that a reasonable person should have done. When writing online about public officials or public figures, the person who claims he has been defamed may even have to show that you knew what you wrote was false, or that you acted with reckless disregard for the truth. This is what the United States Supreme Court referred to in the 1964 case, New York Times versus Sullivan, as actual malice. This is why tabloids and gossip websites are able to avoid many lawsuits. The growth of social media raises new and interesting questions about who's a public figure. For example, if you have 20,000 followers on Twitter, does that make you a public figure? What if you post a YouTube video that goes viral and gets 1 million views? Are you then a public figure? People aren't the only ones who can be defamed. Business defamation, also known as business disparagement, is another potential pitfall relating to online speech. It involves belittling someone's business, goods, or services with a remark that is false or misleading, but not necessarily defamatory. To succeed in a business disparagement case, the plaintiff must prove that, first, the defendant made the disparaging remark. Second, the defendant either intended to injure the business, knew the statement was false, or recklessly disregarded whether it was true. And third, the statement resulted in special damages to the plaintiff. It is very difficult for businesses to win such cases, though, because the actual malice requirement is so high. Courts will only impose liability for business disparagement stemming from online communications in the most egregious cases. Sometimes businesses will threaten frivolous defamation lawsuits as a way to censor criticism, even if it's valid criticism. The business knows it has no chance of winning the lawsuit, but merely wants to intimidate customers, rivals, and others from expressing negative opinions about the business. This practice is known as a strategic lawsuit against public participation, or SLAPP. In response, some states have passed anti-SLAPP laws to fight such abuses. But it still remains a problem. After all, what person wants to deal with the headache of an expensive lawsuit? Web 2.0 and its interactivity raises a new interesting legal issue for online defamation. Can you get sued for defamation comments that people post on your site? The short answer is no. If you operate a blog, discussion board, social media platform, or website that allows users to comment, you are not legally responsible for defamatory comments made by outsiders. The Federal Communications Decency Act should shield you and your website, though the authors of such comments can and do get sued. The reason for this is Congress did not want to stifle web development by placing an enormous burden on website owners to screen every comment for defamation. Without such a law, massive online discussion boards such as Reddit would likely not be possible. You can retain legal immunity even if you voluntarily screen profane or defamatory comments. But if you start rewriting comments to improve them, then you may become responsible as a co-creator. Or if you write your own blog post that quotes someone else making a defamatory statement, you could land in legal hot water, just the same as if you had said or written the defamatory statement yourself. Finally, if you make a defamatory comment online, don't assume you can hide behind anonymity. A court may compel a website to reveal which IP address the defamatory statement came from. And based on that cyberspace address, they may be able to determine your in real life identity. On the other hand, if you operate a website and the police or someone else wants to know who posted comments on your site, you don't need to reveal anything unless they get a court order or a subpoena. Well, that's it. Hopefully now you feel a little more confident in being able to recognize and safely navigate some of the most common defamation traps for the internet.
Okay, so we have seen about online defamation. That was a very good explanation of what is online defamation. I will stop the lecture here and then we will continue this week on online defamation and other types of torts. And for your information, I've uploaded a chapter for you on all these categories of torts. All right, thank you and stay safe.